possibly the last item is in the recommended changes, number 14.
I can speak relatively briefly to this one. This is about violations and penalties. The phraseology that up to 1 year and up to $5,000 is the penalties and time that you would serve if you commit a gross misdemeanor. So it matches up with what the suspect faces if he or she is charged with a gross misdemeanor. And what it says in the state statute is that if you violate the SMA, you committed a gross misdemeanor. So that dollar amount in that time frame match up with what a person would suffer, or the consequences a person would face if convicted of a gross misdemeanor in district court.
I guess one concern when this happens is what happens when things change in one place to the automatic, they get changed in another. You can end up with that $5,000, for example, and if it changes to 10 somewhere.
Right, or that dollar amount that changes every year by the CPI for the SDP, right?
Right, so should we have language that ties it to the code, you know, rather than a dollar amount, so that when the code changes that...
I could certainly look up the definition. I could look up find out the RCW that says here's what a gross misdemeanor
and tie it to that.
What the possible consequences are for a gross misdemeanor, and tie it to that RCW. I can do that. I'll do that today.
And you said an RCW citation that we
Yeah.
would insert. Okay.
Yeah.
I
Sure.
think that'd be cool.
Sure.
Yeah, by the same law.
Yeah. So we did, of course, talk with Ecology about this item also last week, and you know, David was able to kind of talk about that portion of it. We were left with a little bit of a lingering question that Ecology said they would follow up on, and Jeffrey was able to talk to Sonia, looking at that where the strike-through language is, where it currently would show the words "or regulatory order" would be removed. We were looking at that and wondering if instead we should keep the word "or" and instead strike the word "of." You know, the
Right.
strike-through maybe had just been sort of erroneously applied there. And there was agreement that did make more sense. So we would keep the word "or" and strike the word "of."
Agreed, court order or injunction.
Yeah.
Yes.
Yeah,
As a non-attorney, I didn't understand that sentence either.
Okay.
So what I'm hearing is that change would be fine, but we'll look at the RCW and propose language next week that references that instead of stating the time and amount.
Yeah. Doesn't become outdated.
Great. Okay, I think those were the outstanding issues, unless you had additional questions or concerns. It's not really an item on this, it's just sort of a related issue.
Okay.
Yeah, I guess we can brief you that, you know, the board had previously had some other discussions regarding some of the aquaculture provisions, and there was some sort of discussion between the board and staff and with the audience kind of jumping in. We looked to the industry to just have a little bit more dialogue, just to kind of do some sort of test case scenarios and use those as examples, and we haven't gotten feedback. I talked both with Gordon King as well as with Amanda Stock from the firm Blanchet and Stock, who our legal representation to the Shellfish Growers Association. So we'll get more from them hopefully and be able to brief you on that possibly next week.
Okay, you're referring to last Monday afternoon session where we just wanted to make sure everybody was clear and that we remain clear.
Right.
Okay.
Just sort of going through a few what-if circumstances to make sure everyone's clear on how those couple of provisions, D2 and D3, would apply.
Don't want unintended consequences.
Hope to avoid them. Yeah.
So,
council, what further direction or action do you wish from the county commissioners, if any?
I think we've got it for now, and we'll anticipate coming back next Monday with a document that reflects the board's proposal to go to public hearing and a proposed legal notice.
And as part of that, there are a couple of hanging items that you're still working on, so I think board's expectation is that staff, we will be coming forward with some recommendations on those issues and propose specific language on those issues that you haven't seen yet. And so that will certainly, you'll want to give that careful review next week to make sure that that is the guidance, is the proposal that you want to set forward for the public hearing. The procedural question I have, and that is it staff and legal staff's recommendation that the subject of the public hearing be all changes from the locally approved to this next draft that board will be reviewing next week? So would all changes, including all changes, for example, that were required or recommended by Ecology that we're agreeing with, would that be subject of public hearing as well as the areas where we're diverging, or specifically for substance or strengthening the record, wishing to have part of the public hearing? Are you suggesting that all changes be part of the public
Well,
hearing?
that's not what the Whatcom County case said. If you accept what Ecology is offered, you don't have to have another hearing.
Right, but we are picking and choosing, so we have a mix of.
Well, you need anything that you're not agreeing with Ecology, I would say go to public hearing.
Well, and I think we've also identified that there are some areas even where we may ultimately agree with Ecology that we want to go to hearing on in order to be able to enter additional information, either get testimony or enter more
Well, we
information
can,
into the
yeah,
record.
we can do that, but that won't be necessary, that'll be optional instead of mandatory.
Right, and so my question, I guess, is how far the optional goes, and whether we're placing all changes optionally.
Well, you don't need to do that if you're accepting them from
Right.
Ecology.
I'm seeking a recommendation from staff on this topic.
One of the things I could see happening is that, Ecology has required or recommended changes, and then we provide an alternative proposal, and they come back and say, well, this is okay with us now. Okay, does that have to go to public hearing? It's different than what we sent to public hearing the first time. It's, but yet they agreed to it, does that need to be
Seems like the
discussed?
public could still have input,
Yeah.
if that's the case.
I mean, it's always a safe thing to have a hearing, and then you don't hear anything, but.
Right. I mean, I guess I don't see there's anything falling into that category. I guess I don't see nothing has fallen into that category yet of we need more info.
Well, for example, if on net pens.
Except for the net pens, but
And 100-foot docks.
And if we say, okay, we wanna make these changes like what?
well, we can just put those in the public hearing. I think that's the smartest way to go.
Right, okay.
Right.
Anticipate that.
Yeah.
The reason I ask is if the subject of the public hearing is not all changes, but just some changes, then the notice would need to just reflect those changes that are subject to the hearing and not the other DOE changes that we're accepting.
Right, and I think notice could say something as simple as proposed changes to Article 7, ... and then the title of that section. And then there would be a link to where a person could see the full bill line in, line out at the bottom of the public notice.
And what I was just saying is maybe we just make two separate documents. One document for those that essentially were agreeing with Ecology and that don't need to go to public hearing, and those that we don't, the items that we do need to go take to public hearing.
Right.
Separate them out that way.
Yeah. And just have them both come back next Monday and have them both approved by the board by motion.
It's,
Go ahead, Henry.
okay. If Ecology made a required change or recommended change, and we agreed to that change, we don't have to go to public hearing,
Correct.
but the public has had no opportunity to comment
Ecology, yeah.
on Ecology's change.
But that's still, that's what the case holds.
They
And that's what the
come-
statute holds too. The statute says the same thing.
Yeah, I mean, Ecology does have the final authority as the agency, you know, appointed to uphold the statute.
Well, Ecology did have their process on what we submitted to them.
Yeah, they held a public
Right,
hearing
they held a
last
public hearing in
April.
April of 2010, I guess it was.
Right.
April 20th, 2010.
But these are changes from that public
Right.
hearing.
Yeah, that, right, but that's the way the statute's written.
I think it's a question of first impression that hasn't been litigated yet, on whether or not ecology has the whole hearing.
Well, Whatcom County litigated it.
Not on this specific point,
They did before the hearings board.
not in the court, on this specific issue, I don't
Well, they
think.
did with the hearings board, and they never appealed it after that. No one appealed it after that.
Okay, it's informative,
Interesting question.
I think we played safe. Go ahead.
Question.
Yeah, I mean, it's not. Go ahead.
A question for DCD staff and legal staff is there, do you perceive any downside if we were to hold a public hearing on all changes? Is there a negative to that?
Just
I
probably.
think we're likely to get the comments anyway.
Yeah, I mean, I don't know if it's a downside, but it would just be a matter of processing. It would likely result in a larger volume and greater diversity of comments. But
And do you see that as hampering our ability to meet the deadline that we've given Ecology significantly?
It'd just be a longer meeting, we just serve cookies.
In other words, what I'm wondering is whether we need to make the distinction or whether we just do a hearing on the whole thing and play it safe, so to speak.
You can always have a public hearing for whatever you want to have a public hearing on, and then that would be